Ready? Exercise number 9 and 10 legal matter start. The liability of the directors, the controlling authorities of company in a corporate criminal liability is elaborately considered by this court in the case of Sunil Bharti Mittal. In the aforesaid case, while considering the circumstances when director person in charge of the affairs of the company can also be prosecuted. When the company is an accused person, this court has held a corporate entity is an artificial person which acts through its officers, directors, managing director, chairman, etc. If such a company commits an offense involving mens rea, it would normally be the intent and action of that individual who would act on behalf of the company. At the same time, it is observed that it is the cardinal principle of criminal jurisprudence that there is no vicarious liability unless the statute specifically provides for. It is further held by this court an individual who has perpetrated the commission of an offense on behalf of the company can be made an accused along with the company if there is sufficient evidence of his active role coupled with criminal intent. Further, it is also held that an individual can be implicated in those cases where statutory regime itself attracts the doctrine of vicarious liability by specifically incorporating such a provision. Though there are allegations of negligence on the part of hotel and its officers who are in charge of day-to-day affairs of the hotel, so far as appellant accused number 2 Shiv Kumar Jatia is concerned, no allegation is made directly attributing negligence with the criminal intent attracting provisions under sections 336, 338 read with section 32 of IPC. Taking contents of the final report as it is, we are of the view that there is no reason and justification to proceed against him only on ground that he was the managing director of Miss Asian Hotels under bracket North bracket out Limited, which runs Hotel Hyatt Regency. The mere fact that he was chairing the meetings of the company and taking decisions by itself cannot directly link the allegation of negligence with the criminal intent. So far as appellant accused number 2 applying the judgment in the case of Sunil Bharti Mittal, we are of the view that the said view expressed by this court supports the case of appellant accused number 2. By applying the ratio laid down by this court in the case of Sunil Bharti Mittal, it is clear that an individual either as a director or a managing director or chairman of the company can be made an accused along with the company only if there is sufficient material to prove his active role coupled with the criminal intent. Stop. Next exercise. Further, the criminal intent alleged must have direct nexus with the accused. Further, in the case of Maqsood Sayyid versus State of Gujarat and others, this court has examined the vicarious liability of directors for the charges leveled against the company. In the aforesaid judgment, this court has held that the penal code does not contain any provision for attaching vicarious liability on the part of the managing director or the directors of the company. When the accused is a company, it is held that vicarious liability of the managing director and director would arise provided any provision exists in that behalf in the statute. It is further held that statutes indisputably must provide fixing such vicarious liability. It is also held that even for the said purpose, it is obligatory on the part of the complainant to make requisite allegations which would attract the provisions constituting vicarious liability. Next para. In the judgment of this court, in the case of Sharad Kumar Sanghi versus Sangeeta Rane, while examining the allegations made against the managing director of a company in which company was not made a party. This court has held that when the allegations made against the managing director are vague in nature, same can be the ground for quashing the proceedings under section 482 of CRPC. In the case on hand, principally the allegations are made against the first accused company which runs Hotel Hyatt Regency. At the same time, the managing director of such company, who is accused number 2, is a party by making vague allegations that he was attending all the meetings of the company and various decisions were being taken under his signatures. Applying the ratio laid down in the aforesaid cases, it is clear that principally the allegations are made only against the company and other staff members who are in charge of day-to-day affairs of the company. In absence of specific allegations against the managing director of the company and having regard to nature of allegations made which are vague in nature, we are of the view that it is a fit case for quashing the proceedings so far as the managing director is concerned. The order dated 21/8/2015 passed by the Joint Commissioner of Police, by which representation of Miss Gauri Rishi in compliance of order dated 3/7/2015 passed by this court was rejected, is also placed on record. Full stop. Thank you very much.